This is the third video in our series of 4 videos looking at how rights are protected in Australia.
As we've seen, there are 4 ways in which rights are protected in Australia. Firstly, by statute. Secondly, by the common law. Thirdly, by the Australian Constitution. And fourthly, through international declarations and treaties. In this video, we are looking at how rights are protected by the Australian Constitution. There are 2 things that you need to do while you are listening to this video. The first thing is to take the very best Cornell notes you can. The second thing is to use the pause function so that you can pause this video if you need to take notes, and also use the rewind function so that you can rewind this video if you have missed information or need to go back over any information. Once you have finished watching and taking notes on this video, please read section 15.4 of the textbook and supplement your notes with any information from those pages that you think is useful. This section is rather complicated, so in this video I have tried to present the information in a clearer way. For exam purposes, you will only need to know and understand the information contained in this video. In this regard, I have deliberately omitted from this video some of the information contained in the textbook which is not so relevant for you. Here is your learning intention. Evaluate the ways in which rights are protected in Australia, and in this particular video, as I say, we're concentrating on the way in which the Australian Constitution protects rights. As a recap, how are rights protected in Australia? Well, firstly, through statute law. There are statutes that have been passed by the Commonwealth and Victorian parliaments that protect the rights that we enjoy. For example, there is legislation that prohibits people being discriminated against on the basis, for example, of their gender, their sexual orientation, their religious beliefs, or their race. Put another way, we have rights not to be discriminated against on the basis of our gender, sexual orientation, religious beliefs, or race. We've also looked at the Victorian Charter of Human Rights and Responsibilities, which sets out some of the rights that the people in Victoria enjoy. The second way in which rights are protected in Australia is through the common law. The common law is law made by judges when they are deciding cases. And so far, we have looked at the right to silence and the right to a fair trial. These are rights which the judges have developed through making decisions in cases that they have heard. As I've said, in this video, we are going to look at how the Australian Constitution protects rights. We will see that the Australian Constitution protects our rights by restricting the law-making powers of Parliament. For example, you will see that the Commonwealth Parliament is prohibited from making laws that restrict freedom of religion. Later on, we will be looking at how international declarations and treaties protect our rights. The Commonwealth Government has signed a number of international declarations and treaties, for example, the Universal Declaration of Human Rights. Now, these kinds of instruments, that is, declarations and treaties, impose obligations on Australia to protect various rights. However, we, as the Australian people, cannot enforce those rights unless the Commonwealth Parliament has first passed legislation, that is, laws, that give these rights to the Australian people. As set out in the learning intention, in this video we are looking at how the Australian Constitution protects rights. A constitution is a piece of legislation that establishes the political and legal systems for a country. In Australia we have the Australian Constitution, and it establishes the Commonwealth Parliament and the High Court. Some constitutions, such as the United States Constitution also include a Bill of Rights. However, the Australian Constitution, unlike the United States Constitution, does not include a Bill of Rights. A Bill of Rights is a document that sets out the rights of individuals. For instance, the United States Constitution includes Bill of Rights, which sets out certain rights that people in the United States are entitled to. These rights include the right to freedom of speech under the First Amendment and the right to bear arms, that is, to carry weapons or guns, under the Second Amendment. A Bill of Rights directly protects the rights of individuals because it gives rights directly to individuals. Where a person's rights, as set out in a Bill of Rights, have been infringed or breached, then that person can go to court and have the court enforce those rights. Taking the United States as an example, where, as I've said, people in the United States have the right to freedom of speech under their Bill of Rights. Let us suppose that the United States Parliament, that is the Congress, passed a law that prohibited people from criticising the United States government. That law would fairly clearly breach the right of Americans to freedom of speech, and so any American could go along to the Supreme Court and have the Supreme Court declare that law to be invalid because that law is inconsistent with, that is, breaches the Bill of Rights, which is set out in the American Constitution. Alternatively, it could be that, for instance, an employer requires its employees to sign a contract under which those employees undertake not to criticise the employer. Again, that would be a breach of the employee's rights to freedom of speech, and therefore any employee could take the employer to court, and the court would, for example, prohibit the employer from enforcing that contractual provision. That is, if the employee did criticise the employer and the employer tried to sack or discipline the employee because that was a breach of contract, then the court could prohibit the employer from taking that kind of action. The position in Australia is very different. Unlike in the United States, our Constitution does not directly give rights to the Australian people. However, what it does do is it indirectly protects some rights by restricting the power of the Commonwealth Parliament to make laws that breach those rights. If the Commonwealth Parliament were to make a law that breached one of the rights set out in the Australian Constitution, then the High Court would declare that law to be invalid, or, to use a legal term, ultra vires, that is, outside the power of the Commonwealth Parliament. Where a law is declared to be invalid, it no longer applies. It ceases to exist. Let me try to explain this distinction between a Bill of Rights and our Australian Constitution by looking at a specific example. The example that I've chosen to look at is section 116 of the Australian Constitution, which says that the Commonwealth Parliament shall not make any law for establishing any religion, or for imposing any religious observance, or for prohibiting the free exercise of any religion. In shorthand, we would say that section 116 sets out a right to freedom of religion. Now, if we were in the United States or another country that had a Bill of Rights, the Bill of Rights would say that every person has the right to follow whatever religion they choose. You can see that under the Bill of Rights formulation, the right is given directly to every person, and so that right is directly protected. That is, a person whose right to freedom of religion is breached or infringed in some way can go to court and have the court enforce their right to freedom of religion, which they get directly from the Bill of Rights. But in Australia, you can see that section 116 isn't drafted in such a way as to give individuals the right to freedom of religion. What Section 116 says is that the Commonwealth Parliament must not make a law that restricts freedom of religion. This restriction on the Commonwealth Parliament's power to make a law indirectly protects the right to freedom of religion, because even though you and I don't actually have the right to freedom of religion conferred on us by the Constitution does stop Parliament from making a law that restricts freedom of religion. Now, you might ask, well, does this really matter? Under both a Bill of Rights and under the Australian Constitution, the right to freedom of religion is protected. Well, the answer is it does really matter. If we take the position of a Bill of Rights, then a Bill of Rights gives that right to freedom of religion directly to individuals, and this means that no Parliament, no government, no other person can breach this right. So, for instance, if we had a Bill of Rights in Australia which gave people the right to freedom of religion, and if the Victorian Parliament passed a law that prohibited people from following a particular religion, for instance from becoming Christians, then that law would be invalid. That is, it would have no effect. And that's because it is a law which breaches the right to freedom of religion which every individual in Victoria would have. However, remember that the Australian Constitution only prohibits the Commonwealth Parliament from making a law that restricts religious freedom. This is not a restriction on the state parliaments, on governments, or on any other people in Australia. State parliaments, governments, other people, they can all do things that restrict a person's religious freedom because the provision in the Constitution only binds the Commonwealth Parliament not to make laws that restrict religious freedom. For instance, it would be perfectly valid for the Victorian Parliament to make a law tomorrow that prohibited people from following a religion. For example, a law that prohibited people from becoming Christians. That's not to say that the Victorian Parliament would make such a law, because you can imagine that at the next election the government would be voted out, but as a matter of legal principle, the Victorian Parliament could make a law that restricts religious freedom in Victoria. It is not bound by the restriction in the Constitution that protects religious freedom. Let's now look in a bit more detail at the rights that are protected by the Australian Constitution. For these purposes, there are two kinds of rights that are protected by the Australian Constitution. The first kind of rights is express rights. The second kind of rights is rights that are read into the Constitution by the High Court. Turning first of all to express rights, an express right is a right that is set out in a constitution. Express rights are protected by the Australian Constitution because the only way in which those rights can be changed or removed is by changing or amending the Constitution itself. And that's because the express rights are actually written into the Constitution. They form part of the words of the Constitution. Now in Year 12, we look in more detail at how our Constitution can be amended. But for present purposes, all you need to understand is that our Constitution cannot be amended by the Commonwealth Parliament acting alone. The Commonwealth Parliament can amend or change ordinary legislation by simply passing a statute that amends that legislation. However, the Constitution is not ordinary legislation. In the case of the Constitution, it can only be amended if that amendment is also approved by the Australian people voting at a referendum. A referendum is a compulsory public vote. Put another way, our Constitution can only be amended if the Australian people agree by voting in favour of that amendment. Now that might sound very easy, but in practice it's actually quite hard to get the Australian people to agree to amend our constitution. Since 1901, we've had 44 referendums to change the constitution. And in only 8 of those referendums did the Australian people approve the change that was proposed to the constitution. So you can see that our constitution is very effective in protecting express rights, because the only way those rights can be changed or removed is by amending the constitution. That amendment requires the approval of the Australian people voting at a referendum, and as a matter of practice, that approval is generally pretty hard to obtain. Let's now look at a couple of express rights. There are actually 5 express rights set out in the Constitution, but we're only going to look at 3. The first express right, the right to freedom of religion, is one that we've looked at already. Under section 116, the Parliament, or the Commonwealth Parliament, cannot make any laws that establish a religion, impose any religious observance, or prohibit the free exercise of any religion. As we've already seen, this is only a restriction on the Commonwealth Parliament. So state laws can interfere with religious freedom. And again, that's the point of distinction between our Constitution, which indirectly protects rights, and a Bill of Rights, which would give the right to religious freedom to everyone in Australia, so that no one, whether it's a parliament or a government or another person, can interfere with religious freedom. Second express right is the right to trial by jury under section 80 of the Constitution. Section 80 provides that trials for indictable, that is more serious, Commonwealth offences must be jury trials. Again, this is only a restriction on the Commonwealth Parliament. It would be perfectly valid for the Victorian Parliament to pass a law that provided for Victorian indictable offences to be tried by a judge without a jury. You can't do that at the Commonwealth level. The Commonwealth Parliament can't pass a law that takes away the right to jury trial for Commonwealth indictable offences, but a state parliament is not bound by section 80, and so it could pass a law that took away the right to people to have a jury trial in the case of indictable state offences. The third express right is the right to compensation for compulsory acquisition of property. When we refer to the compulsory acquisition of property, we mean that that property is taken away from the owners of that property, typically by a government, even though the owners might not want to part with that property. This happens quite frequently in Australia when roads are being built. If houses are along the route that the road is to follow, then the government will simply compulsorily acquire those houses, that is, take those houses away from the house owners, whether or not they want to sell those houses. The government will take them away and demolish them so that it can build the road. Now, section 5131 of the Constitution states that the Commonwealth Parliament can make a law for the compulsory acquisition of property. However, if the Parliament makes such a law, then that law must also provide for the acquisition to be on just terms. That is, that law must also provide for the Commonwealth to pay fair and reasonable compensation to the owners of that property. To go back to our roads example, if the Commonwealth government decides to build a road and it needs to acquire people's houses to build that road, then it can compulsorily acquire those houses. However, the Commonwealth government must pay fair and reasonable compensation for those houses to the house owners. Note that, like the 2 previous express rights, this is only a restriction on the Commonwealth Parliament. It's not a restriction on state parliaments. So, if the state government wanted to build a road, then the state parliament could pass a law that authorised the state government to compulsorily acquire the houses of people where those houses were in the way of the road, and that law would not have to provide for the acquisition of those houses to be on just terms. That is, the state government would not necessarily be obliged to pay compensation for acquiring those houses. As a matter of practice, of course, the state government does pay fair and reasonable compensation where it compulsorily acquires people's property. But the fact remains that under our Australian Constitution, there is no requirement that the state has to pay fair and reasonable compensation where it acquires someone's property compulsorily. This then brings us to the second kind of rights which are contained or protected by our Constitution, and these are rights which are read into the Constitution by the High Court. Under the Australian Constitution, it is the High Court which is given the power to interpret the Constitution, that is, to give meaning to the words in the Constitution. And this is the reason why the High Court is sometimes referred to as the guardian of the Constitution. Now, the High Court has interpreted the Constitution to include certain rights. These rights are not express rights. They're not rights that are actually set out in the Constitution. You won't see them written in the Constitution. But these are rights which the High Court has said are implied from the words of the Constitution. These rights are protected by the Australian Constitution because no Parliament has the power to pass a law that abrogates or overrides the High Court's interpretation of the Constitution. You'll recall from some earlier work that we've done this year that, generally speaking, Parliament is supreme. That means that Parliament is able to make laws, change laws which it has made, and abrogate or override laws which are made by the courts. A very important exception to that, though, is that where the High Court interprets the Constitution, then no Parliament can override the High Court's interpretation of the Constitution. Therefore, where the High Court has interpreted the Constitution to include certain rights, no Parliament can pass legislation which takes away or changes those rights. To understand the most important rights that the High Court has read into the Constitution, we need to look at the concept of representative government. Sections 7 and 24 of the Constitution state that the members of the House of Representatives and the Senate must be directly chosen by the people. The High Court has interpreted these sections to mean that Australia must therefore have a system of representative government. Representative government means a system of government where the government consists of representatives of the people who are chosen, that is elected, by the people. And this is an important concept because such a government should therefore represent the views of the majority of the people. In Australia, we clearly have a system of representative government because at each federal election, we go along to the polls and we elect those people who are to represent us in the House of Representatives and the Senate. And those people who obtain a majority of votes, those are the people who are sent into Parliament. And if they have the majority of votes, then fairly clearly they should be representing the views of the majority of the people. Now, the High Court has held that this requirement for representative government gives individuals certain rights. And in particular, there are two rights that we're going to look at. The first is the right to vote, and the second is the right to freedom of political communication, which simply means the right to freely discuss and debate political issues. Turning first to the right to vote, the High Court has held that for there to be representative government, which is a requirement of our Constitution, then the Australian people must have a right to vote. And this makes sense because the whole basis of representative government is that the people choose their representatives. The way they choose their representatives is through voting. So therefore, the High Court has read into the Constitution that the Australian people must have a right to vote. Note that when you read the Constitution, nowhere will you find the right to vote set out in the Constitution. It's simply not referred to. Instead, this is a right that the High Court has read into the Constitution because the Constitution requires us to have a system of representative government, and because a necessary feature of representative government is that people have the right to vote. If we were in a Bill of Rights country, then the Bill of Rights might well say that everyone has the right to vote, at least if you're 18 or over and an Australian citizen. However, we do not have a Bill of Rights, and our right to vote is only indirectly protected. What the High Court has said is that the requirement for representative government means that the Commonwealth Parliament cannot make a law, that is, they're prohibited from making a law, that takes away a person's right to vote. The most important case that deals with the right to vote is Roach against the Electoral Commissioner, and you'll find that on page 497 of your textbooks. I'd like you to read that case. You'll see that in this case, the High Court ruled legislation invalid where that legislation prohibited any person who was serving a sentence of imprisonment from voting. The reason the High Court came to this conclusion was that there are many people who are serving a sentence of imprisonment for very minor offences, for example, because they've failed to pay parking fines. And the High Court thought that in these sort of cases, it was inconsistent with representative government for these people to be denied their right to vote. However, the High Court also said that it was reasonable to take away a person's right to vote where that person was serving a sentence of imprisonment for a serious offence. So that meant that Commonwealth legislation that took away a person's right to vote where that person was serving a sentence of imprisonment for more than 3 years was valid. It wasn't inconsistent with people having a right to vote. Similarly, legislation which takes away the right of insane people to vote or the right of people who've been convicted of treason to vote would also be valid. In the case of insane people, they're incapable of making the choice which is necessary to effectively participate in an election. It's therefore okay to take away their right to vote. In the case of people who've been convicted of treason, they have shown that the way they want to change the government is by force, not through the ballot box. And in that case, again, it's not inconsistent with representative government to take their right to vote away from them because they don't value the right to vote. They've sought to change the government not through voting, but through force instead. This brings us to the right to freedom of political communication. In a series of cases, the High Court has held that for there to be representative government, the Australian people must have the right to discuss and debate political matters. Now this makes sense because for people to be able to make an informed decision at an election about who to vote for, they need to be able to discuss and debate political matters that will influence the way in which they vote. As with the right to vote, you will nowhere find in our Constitution the right to freedom of political communication. Instead, this is a right that the High Court has read into the Constitution as a result of our Constitution requiring us to have a system of representative government. That is, for us to have a system of representative government, it's necessary that people are able to discuss and debate political matters. If we were in a Bill of Rights country, then it's quite possible that the Bill of Rights would give everyone the right to discuss and debate political matters. However, we do not have a Bill of Rights, and so this right is only indirectly protected. What the High Court has said is that the fact of representative government and the associated right to discuss and debate political matters means that the Commonwealth Parliament is prohibited from making a law that restricts the right to freedom of political communication. An important case on this right to freedom of political communication is Australian Capital Television Proprietary Limited and the Commonwealth. You will find this on page 495 of your textbooks, and I'd like you to read that excerpt. This was a case in which there was Commonwealth legislation which banned political advertising during the election campaign period. The High Court held that this legislation was invalid because it restricted the ability of people to debate and discuss political matters. So it was inconsistent with the right to freedom of political communication. Now, this doesn't mean that all laws that restrict the right of freedom of political communication will be invalid. Instead, in other cases, the High Court has held that where a law restricts the freedom of political communication, but has another legitimate purpose, and that restriction is reasonable, then that law will still be valid. A principal case where this point was made was the Levy case. This was a case in which Victorian legislation prohibited a person from entering a duck hunting area unless they were a licensed shooter. The person who brought the case, Mr. Levy, was actually opposed to duck hunting, and he wanted to enter into a duck hunting area to film what was going on there, to show the massacre of the birds that was happening, and therefore to persuade people to vote against duck hunting. Well, in this case, the court held that the legislation that banned people from entering a duck hunting area unless they were licensed, that legislation was valid. This was because it had another legitimate purpose. That is, it had the purpose of safeguarding people, so to avoid them being at risk of being shot, because of course that's what happens in duck hunting areas. And it was also valid because the restriction on the right of freedom of political communication was a reasonable one. There was nothing stopping Mr. Levy standing 1 metre outside the duck hunting area and filming the duck hunting and talking on film about how terrible duck hunting was. There was nothing which prevented Mr. Levy from going on national TV and national radio and broadcasting his views about duck hunting. In the next 2 slides, I'm taking you back to your learning intention, which is that you need to be able to evaluate the effectiveness of, in our case, the Australian Constitution in protecting rights.
These next 2 slides consist of a table that sets out the strengths and weaknesses of the Australian Constitution in protecting rights.
I'm not going to take you through these tables because the material in it is material that comes from what we've already discussed in the video. What I'd like you to do, though, is to draw up your own tables and in your own words describe these strengths and weaknesses.
I want you to do this because your next task will be to write up an evaluation in which you evaluate the effectiveness of the Australian Constitution in protecting rights.
To do an evaluation, you need to weigh up strengths of the Australian Constitution in protecting rights against the weaknesses of the Australian Constitution in protecting rights. So again, to reiterate, after watching this video, you should be able to evaluate the ways in which the Australian Constitution protects rights in Australia.
Well, that brings us to the end of this video. Don't forget to read the pages from the textbook referred to on the first slide, and if you find any additional information from that reading that is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.